exclusive. Just Mediator Jacobson's just coming in and he'll be quiet. Always got to do that to Jake. This is a global but quasi-private event. With extraordinary modesty, John Sackar said he wasn't going to have a launch of this book, and I spent 10 or 15 seconds convincing him that that wasn't a good idea. And I then immediately dobbed Leeming JA in to launch the book. So my function is simply to welcome you and to introduce Mark, who knows no introduction, nor does the author, but also to invite you as an inducement to nobody walking out during the speeches to a glass of champagne to celebrate the achievement in the judges' dining room immediately after the speeches, which should be about 6:30 or so, I would imagine. Justice Leeming.
Thank you very much, Andrew. It's a great honour to participate in a small way in this launch. Patrick Devlin, 1905 to 1992, was not a typical judge. The internal life is fascinating. Young boy, Irish Catholic background, sent to remote Stonyhurst College in the north of England, educated by Jesuits throughout the war. He became a novitiate aged 16 in a Dominican monastery. He departed abruptly 8 months later in circumstances never fully explained. At Cambridge, his faith lapsed. He got a very ordinary degree, but he met Madeleine Oppenheimer, with whom he fell in love at their first meeting. And the most striking photograph in this book is the couple on their wedding day in 1932. He, grimly unsmiling, in an oversized overcoat. No bridal gown for her. She is wearing a smart black leather jacket. I found myself wanting to know more about the wife of 60 years, raised in the Jewish tradition, wealthy from South African diamonds, one of very few female undergraduates in Oxford in the 1920s, the mother of 6 children, who later became a magistrate and ultimately converted to the faith renounced by her husband. But to return to the public side of Devlin, he was medically unfit for service in World War II, rickets from that boarding school in the north, joined the Home Guard, practiced commercial law, High Court judge aged 42, no small feat, on the same day that Denning was made Lord Justice of Appeal. And the careers of Devlin, Denning and Viscount Dilhorn intertwined over the next 30 years. Devlin served 12 distinguished years on the King's Bench before being appointed to the Court of Appeal in 1960 and the House of Lords in October 1961. He resigned just over 2 years later, in January 1964, after 15 years of service, to run the newly established Press Council and to write some of the most famous works by judicial authors in our language. Some are well known today, the exchanges with Hart on law and morality. Some are much less well known, the criminal prosecution in England, highly influential at its time, and a 750-page biography of Woodrow Wilson. Oxford University Press published a collection of his books, of his papers, in a book called, a little unimaginatively, I think, The Judge. And then there was that book, Easing the Passing, where, as you can see, Faber and Faber were very unimaginative 3 years later in their choice of cover. Easing the Passing is Devlin's account of the most famous trial he presided over, the prosecution of Dr. John Bodkin Adams for murdering his elderly patient. It caused an enormous ruckus at the time. Justice John Sackar is not a typical judge. The research underlying the book is deep and meticulous. The work is based on a close familiarity with primary records, many of which have not, I suspect, been consulted by any scholar for decades, if ever. I have some idea of how painstaking and time-consuming such research can be. To do so while a serving judge is an astonishing feat. Justice Sackar has written a work of judicial biography bringing to bear not only a forensic precision in the surviving documentary evidence, but also, and this is one of the great strengths of this work, an insight from an experienced judge of the challenges Devlin confronted as a judge. Virginia Woolf once wrote that a good biographer required gifts analogous to the poets or the novelists. Biography, even legal biography, is inherently creative, with choices to be made at every sentence. I think Woolf would agree that it's a fine thing for the world that a sitting judge has found time to write this work about one of the most influential and enigmatic judges of the 20th century. But Lord Devlin, by Justice John Sackar, is not a typical judicial biography. It's the biography of a man with a really interesting life, extending far beyond the law, and with an ongoing narrative arc reflecting the tension and conflict between Devlin and Dilhorn, culminating in easing the passing. Sackar's book lets Devlin's own voice shine through, and those words are glorious. His prose, in judgment, in speech, and especially in private correspondence, is precise, crisp, playful, and very often with a sting. There isn't time today to survey the whole work. May I mention just a few aspects with a view to illustrating how the man and his biography may appeal to an Australian audience in 2020. First of all, Royal Commissions. Chapter 8 is devoted to Devlin's work on the Nyasaland Commission. In the aftermath of the Mau Mau insurrection in Kenya, there was evidence of a planned general strike, civil unrest and serious violence in Nyasaland, which is now called Malawi. The government declared a state of emergency. Troops were brought in from what was then known as Southern Rhodesia. Hundreds of people were detained, many were killed or wounded. To its credit, the Macmillan government commissioned an independent inquiry on the 19th of March 1959, with the expectation of an outcome sympathetic to the governor. Devlin was an experienced judge with 10 years' service. He was appointed to chair that inquiry on the 24th of March. He arrived with 3 other commissioners on the 9th of April. He spent 5 weeks hearing evidence from 455 witnesses. He received 585 submissions. He conducted a further week's hearing in London. The inquiry concluded on the 26th of June. Devlin worked 15 hours a day over the next week, circulated a draft on the 7th of July, served the final report on the 15th of July. Much has changed in the past half-century in the way Royal Commissions are run. I'm not suggesting for a moment that every Royal Commission can report so promptly. Much depends on the terms of reference and the nature and the purpose of the inquiry. Devlin found and reported in language which left the evidence to tell its own story that there'd been extensive beatings, bullying, burning, confiscation of property, and not merely against supposed offenders, but against the population generally, authorised or condoned by the colonial government. This wasn't hidden in one of the later paragraphs of the report. The report begins with Devlin's typical blunt precision. Quote, "Nyasaland is, no doubt only temporarily, a police state where it's not safe for anyone to express approval of the policies of the Congress Party, to which, before 3rd March 1959, the vast majority of politically minded Africans belonged, and where it is unwise to express any but the most restrained criticism of government policy." That government policy, of course, was the British colonial government policy. The report stated very pointedly, quote, "The government has not at any time, either before us or so far as we are aware to anyone else, expressed any regret for or disapproval of what has been done. We record this as a fact, and not as indicating that any express or regret or disapproval is necessarily appropriate. That's a matter for you." The report didn't prevent Macmillan's re-election later in 1959, probably did encourage Macmillan's Winds of Change speech in 1960 and the speeding up of decolonialisation. The Spectator, not a journal well known for its liberal viewpoint, said of the report, "It will rank as one of the great documents on colonial affairs, and it surveyed the whole scene in Nyasaland and interpreted it with great insight and penetration. In short, it made a difference." The report didn't prevent Devlin's elevation the following year to the Court of Appeal, and then in October 62 to the House of Lords. And this is a little poignant. Devlin, who was very vain and far more concerned than he should have been for his reputation, was dreadfully concerned that his prospects of promotion had been stymied by the report. Yet, at the same time, he was perfectly self-aware and realistically feared that he would hate promotion to the appellate bench if it were offered, and so it proved. Devlin liked trial work and he was good at it. He disliked hearing appeals. He was years younger than any of his colleagues on the House of Lords, and his brain worked faster. That short stint in the House of Lords occurred at a tremendous time. Viscount Simons had finally retired in 1962. Lord Reid had become the senior law lord. Change was in the air. In 1964 appeal cases, you can find, if you can find the volume, a little bit like volume 194 of the Commonwealth Law Reports, it's apt to go missing because it contains cases which are so constantly cited. But in 64 AC, there's Hedley-Byrne and Heller, Rooks and Barnard, Ridge and Baldwin, and Lewis and Daily Telegraph. Hedley-Byrne did as much as anything else to promote the imperial march of the modern law of negligence. Ridge and Baldwin did much the same, if not more, for administrative law. Lewis and Daily Telegraph remains a classic in a number of basic aspects of the law of defamation. A quick check shows that in this year of the pandemic, which hasn't favoured defamation trials, Lewis was cited and applied by appellate courts in South Australia, Western Australia and the ACT, 3 times by the Supreme Court in this state, many times by the Federal Court, and in almost every case it's Lord Devlin's speech of 56 years ago that's cited. Subtle, clear, precise, and written in well-drafted English prose. The sentences that Lord Devlin wrote are so familiar they've become institutionalised aspects of a defamation trial. Let me give you some examples. For the purpose of the law of libel, a hearsay statement is the same as a direct statement, and that's all there is to it. A company cannot be injured in its feelings, it can only be injured in its pocket. A man who wants to talk at large about smoke may have to pick his words very carefully if he wants to exclude the suggestion that there is also fire, but it can be done. This mimetic quotability is not necessarily a good thing. I'm reminded of Robert Stevens' argument that it's important for the law to be as boring as possible in order to preserve its scope for dealing impartially with the divisive constitutional questions which from time to time will arise. But Devlin's prose does make this book eminently readable in the same way that one can enjoy biographies of Holmes and Brandeis and Learned Hand for the same reason. There are other links with those great American judges too, to which I'll come in just a moment. If you're interested in the sausage making that goes on in some appellate courts behind the scenes, Justice Sackar gives a fascinating account deriving from Reid's surviving notebooks of the changes in the outcome of some of those appeals in 1964. The junior law lord appears to have shaped the outcomes of some of them. For example, after the first hearing in Rooks, Devlin was in a minority of 1 or maybe 2 favouring the appellant. But eventually, the entire bench allowed the appeal, leaving it to Devlin to write that famous restatement of the law of exemplary damages. This was, of course, also a momentous time for the relationship between the Australian legal system and the House of Lords. Devlin's reformulation of exemplary damages led to a response by the High Court of Australia, notably by Justice Windy in Uren, an Australian Consolidated Press, at a time when the High Court was still bound by the Privy Council and expected to adhere to decisions of the House of Lords. Justice Windy, following what had been said by the Chief Justice in Parker, had pushed back against this in his eloquent exposition of the dynamism of the common law in Skelton and Collins. And that in turn led to the important statement by the Privy Council on appeal from Uren endorsing the separateness of the common law of Australia from that of England. and it led to what was perhaps the most famous statement of the unwisdom of joint judgments in important areas of where the law was still developing a few years later in Broome and Cassell, an echo of which perhaps might be seen in last month's decision in Caledad and Sackar Epson, and certainly in many decisions of the Court of Appeal in those relatively rare cases where the court is not unanimous. Of course, there are occasions when important decisions should be unanimous. The error is thinking that there's a one-size-fits-all approach. That's at least how it seems to me. Devlin, when working in the Library of Congress in 1958, working on his biography of President Wilson, Too Proud to Fight, Woodrow Wilson's Neutrality, met Frankfurter, and in that way met the latter's former student, Dean Acheson, that time in private practice after he'd served as Truman's Secretary of State. Chapter 6, titled Friends Across the Atlantic, reproduces extensive correspondence between the three men. Devlin was delightfully pointed, and it must be said, downright rude, in his private correspondence. The book contains superb, often caustic, portraits of judicial figures. Devlin wrote to Frankfurter of Lord Denning, quote, "He wasn't an effective advocate, taking all points, good and bad, and cut no figure at the bar. When in 1944 Simon decided to enlarge the divorce judiciary and knew he'd have to recruit from the common law bar and probably couldn't attract the highest, he offered a place to Tom, who'd impressed him doing a poor person's case in the House of Lords. It at once became apparent that Tom was an outstanding judge and that he couldn't be left in divorce, and he was speedily moved to the KB. Of course, Tom is very unorthodox and frequently seems to regard legal principles as a means to an end. But a very little of that sort of thing is not bad for the law of England, and Tom has great qualities to go with it." Of the newly appointed Lord Pearce, whom you may not have read or cited recently, but who replaced Lord Denning in the House of Lords, Devlin wrote this to Frankfurter: "He and I were appointed to the bench on the same day, he going to divorce and I to the KB. He is a really nice and delightful man, of no particular ability. I was surprised when he was made a judge, astonished when he was moved to the KB, flabbergasted when he was appointed to the Court of Appeal, and it never so much as crossed my mind that he'd be considered for the Lords. But as I've now been proved wrong at all these four stages, you'll understand that he must be highly esteemed in quarters that matter, and you do much better to accept their valuation than mine." And then there's that book, Easing the Passing, first published in 1985, the account of a highly unusual murder trial written by the presiding judge almost 3 decades later, after the deaths of most of the actors. Part of its fascination is the insight given to the reader of what the judge was thinking, what he inferred from the conduct of the Crown and the defence, how he thought authority required him to direct the jury, and so on. For example, there's this passage: "The defence has now to ask themselves and to answer a crucial question. Had Reggie missed the point, or was he keeping it reserve to ask at the deadliest moment of cross-examination? If the latter, Adams must not be called. I'm sure the Defence Counsel took the right course in keeping the accused out of the box and risking the consequences. It was a courageous decision. Insofar as it was a gamble, it came off. Reggie hadn't got the point." And then there's a marvellous recreation of what would have occurred if the accused had been cross-examined. "Counsel and witness would have been fighting with weapons as different as those of the gladiator with his sword and the retiarius with his net in the Roman amphitheatre. Reggie with a sabre, for he'd be a slasher rather than a fencer, would score many hits. But an advocate doesn't get a verdict for murder by winning on points. To win, he must capture, hold and convince the mind of the jury. For that, the net is the more potent weapon. Reggie was not an artist like Lawrence, who's the defence counsel. He wouldn't even remotely have understood the mental processes of Dr. Adams. If Adams was a murderer, he was not the crude sort that Reggie believed him to be." Reggie, of course, was the Attorney General, Sir Reginald Manningham Buller, later Viscount Dilhorn. The put-downs of Reggie display Devlin's mastery of language. They include this: "He was neither a saint nor a villain, but since most of his convictions were wrong-headed, he was ineluctably a do-badder. by which I mean a person whose activities bear the same relationship to villainy as those of a do-gooder do to sanctity. The prose is very lively. Please indulge me, I can't resist quoting the first sustained description of the Attorney-General of the United Kingdom. Referring to Lord Birkenhead's famous and rather shallow address about the glittering prizes offered to those who have stout hearts and sharp swords, Devlin wrote, "Reggie never learnt swordsmanship, but he was effective with a blunt instrument, and he certainly had a stout heart. What was almost unique about him and makes his career so fascinating is that what the ordinary careerist achieves by making himself agreeable, falsely or otherwise, Reggie achieved by making himself disagreeable. Sections of the press, which he permanently antagonised, liked to parody his name by calling him Sir Bullying Manner. This was wrong. He was a bully, but without a bullying manner. His bludgeoning was quiet. He could be downright rude, but he didn't shout or bluster. His disagreeableness was so pervasive, his persistence so interminable, the observations he made so far-fetched, his objectives apparently so insignificant, that sooner or later, otherwise, you'd be tempted to ask yourself whether the game was worth the candle. And once you asked yourself that, you were finished." Devlin went on to compare the attorney to Widmerpool, in many respects the star of A Dance to the Music of Time, noting that the reappearance of Widmerpool in successive volumes of the novel sequence, each time surprisingly on a higher rung of the ladder, are glimpses of how Reggie's climb in real life appeared to his contemporaries. And indeed, the photograph of Sir Reginald Manningham Buller in the volume strangely recalls Simon Russell Beale's portrait of Widmerpool in the miniseries on television. Then, to add to the drama in Sackar's story is the fact that Devlin was far from altruistic or disinterested in his criticism of Reggie, because while the Bodkin-Adams trial was being heard, both Devlin, the judge presiding, and Manningham Buller, the attorney prosecuting for the Crown, were the leading candidates for the soon-to-be vacant office of Lord Chief Justice of England. There were stories in the press about this. There's no reason to doubt that each was aware of the other's ambition. Devlin was the most capable judge on King's Bench and favoured by Lord Goddard. Manningham Buller sought to invoke the ancient, dubious right of the Attorney-General to any of the four great legal offices judicial offices of state which chanced to become vacant during his tenure. As it happens, both missed out. Lord Parker was appointed. There's been much speculation about Devlin's early retirement from the House of Lords in 1964. One distinguished commentator linked it with a despair at the continued vitality of the common law to keep the executive in check. Certainly Dillorn's elevation as Lord Chancellor later in 1962 made the position less attractive to Devlin. But the correspondence with Dean Acheson, reproduced in this work, shows that Devlin's early retirement was far from unforeseen. In August 1960, he told Acheson that while he expected to receive the next common law vacancy in the Lords, he doubted he'd stay past his 15-year service. He wrote this: "I do not find appellate congenial and can't contemplate another 20 or 25 years of it. Our methods are so tedious compared with yours. We spent hours sitting in court listening to evidence, documents and law reports being mumbled at a pace that suits the very slowest mind and leaves anybody who is not ritualistically disposed with eternities that decorum forbids him to occupy." That was the Court of Appeal. It was even worse in the House of Lords. A letter to Frankfurter, again reproduced in this book, states that he thought it would be enjoyable to hear and determine appeals in the same way as the United States Supreme Court did. "I find our practice of going into the case with a blank mind and listening to days and days of argument quite intolerable. If it were all genuine argument, it would be bad enough. For after all, if a man cannot get at the point that really matters much more quickly than the average counsel, he ought not be sitting on the Supreme Appellate Tribunal. But it's not even all irrelevant argument. Days, literally days, are occupied with reading out loud the records of evidence and the judgments and the relevant authorities. You cannot even pick up a law report and read the parts that you think matter instead of the parts that counsel thinks matter, because there are never enough copies to go around. And you have to look over your neighbour and exchange polite glances when the time comes to turn the page. The real vice of this is that while days and days are wasted in this sort of activity, no time or facilities are given for what I really think matters. That is, some independent research, thorough discussion with colleagues, and a careful preparation of drafts of the judgment. And this is no exaggeration. If you go back to 1964 appeal cases, Ridge and Baldwin was an 8-day appeal. Brooks and Barnard was a 15-day appeal. 10 days in July, followed by 5 days in November. Hedley, Burns and Heller was an 8-day appeal. Lewis and the Daily Telegraph was a 9-day appeal. Even Pilkington and the Internal Revenue Commissioners, a case on the power of advancement of the law of trust with no facts whatsoever, in which Devlin simply agreed with Radcliffe, took 3 days to argue. I have to say, I personally regarded these statistics with mounting horror and a profound sense of relief that things have changed. But it was the same here. If you pick up volume 113 of the Commonwealth Law Reports in 1964, when Dixon retired and Barwick was appointed, Latec Investments and Hotel Terrigal was argued over 4 days. The First Airlines of New South Wales case was heard over 7 days. Sir Anthony Mason stated how the sharpening of oral advocacy, getting rid of this tedious reading out of authorities and the record, was the greatest change and wholeheartedly for the better. But for Devlin, who was denied even the marginal pleasure of perusing the balance of the volume of the law reports because of the slowness of his more senior appellate colleagues, it must have been absolute agony. Justice Sackar lets Devlin's own voice shine through in this work, accompanying it with occasional insights from the author's own judicial experience. I found it the best judicial biography I've read for years. Time prevents me from attempting to summarise all of the delights, and in any event there should be some surprises. One is Macmillan's private diary entry when first learning of Devlin's report, see page 141. But may I conclude with these 3. First, there's a foreword by Lord Phillips of Worth Matravers, who tells readers that his clerk, who'd also clerked for Devlin, used to compare his barristers unfavourably to Devlin when, and apparently not infrequently, they didn't measure up to Devlin's standards. Secondly, there's an 18-page appendix of biographical details of some 70 of the main actors in Devlin's life. I found these short sketches, each a substantial paragraph of 100 words or so, immensely useful. And future readers, because I'm confident this book will be read for many years, will increasingly benefit from it. Thirdly, the book is beautifully produced, 260 pages with 19 well-reproduced black and white photographs and a jacket with a marvellous charcoal sketch by Ronald Searle, perhaps more famous for his illustrations for St Trinian's, the comic strips. The production values have immensely improved since these paperbacks in the 1970s and the 80s. It's a delight to read and also delightfully well priced by a publisher who has, I expect, rightly anticipated a large print run. In short, an Australian judge has written an eminently readable, thoughtful, nuanced biography of one of the more famous English judicial figures of the 20th century. It's a pleasure to read, and it will solve a perennial problem in this month. What to give for Christmas for that hard-to-shop-for lawyer, spouse or relative or friend. I am delighted to commend Lord Devlin by Justice John Sackar to you.
What can I say? The President told me that this evening I should regard modesty and brevity as a synonym, and so I will be short. Justice Leaning, I'm grateful for your overly kind words. It's not the first time, however, you've reviewed my work, and but I have to say it's the best result I've ever had in the Court of Appeal. When I joined the Equity Division next February, 10 years ago, there were many judges who, were anxious to assist me in my transition. There were helpful hints on what to do, how to actually be a judge, and some sought to advise me on what I should do in my periods of long leave. Justice Ken Handley suggested that any long leave I might take would be well used remodelling and amplifying the 1908 work on actionable defamation by George Spencer Bower. Justice Peter Young, on the other hand, had a more lively idea. He suggested I might like to remodel and amplify Percival E. Jackson's 1937 work on the law of cadavers. It will come as no surprise that I decided, therefore, to write a biography of Lord Devlin. The Equity Division, of course, has had a tradition of writers in residence, and I was able to consult one of the erstwhile members of the division on the topic of how to balance the work of judging and writing. He dealt with those topics, of course, in reverse order, and he gave me some very bold, if not ingenious, methods that he had adopted, which he thought made best use of writing time as opposed to practice management, none of which in the end I thought I could employ. However, I started this work in 2015 with some trepidation, because judicial biographies are often written by retired judges or barristers, often recounting the finest hours of their work day and often to the point of wrist-slashing tedium. Others, like Norman Poser, who wrote a magnificent biography of Lord Mansfield, warned prophetically that choosing the subject of a biography was much like choosing a mate. One is destined to spend years with that person, so you'd better choose wisely. But why Devlin? Well, there are several responses, some of which Justice Leeming has articulated this evening. He was one of the giants of the legal profession. He was prolific in his output. He possessed a luminous intellect, and for good measure, he was enigmatic. As a law student in the 1970s, I hate to admit I was a law student in the 1970s, I became aware of Devlin's punch-up with Professor Herbert Hart over law and morals, and it then became a staple for most jurisprudence courses in the common law world. The choice of which protagonist to support was decided almost on party lines. Devlin, in his 1959 Maccabean lecture, had started the ball rolling by suggesting to the world at large that the reforms articulated by Wolfenden to decriminalise homosexual behaviour and prostitution should be rejected. So the two commenced a boxing match which went on for many years. It actually provoked in Herbert Hart one of the best books ever written on jurisprudence, and you'll read more about that in the book. Now, over the years, by happenstance or otherwise, I kept bumping into Devlin. It was extraordinary. Not only did I go back and read out of pleasure some of his judgments and books, but I was intrigued as to why a man who attained at 58 the pinnacle would then leave the House of Lords in rude health. And so I set about a task to try to solve the riddle. I sort of got there, I think, in the end, and I think Justice Leeming articulated it this evening. What Devlin told everyone he wanted to do was not to speak to people in the United Kingdom. He was telling people in the United States what he was thinking more directly than he was certainly in the United Kingdom. He was bored, and he was bored witless, because he was so active intellectually, so imaginative, so innovative and so productive that most of the people around him bored him, even though Reid and Radcliffe and people of that ilk were some of the finest intellects of their day. They couldn't think like Devlin, they couldn't think as quickly as Devlin, and they weren't really interested in reforming court process. And some of the statistics which Justice Leeming talked about this evening are in the book, and one just looks in horror at how many days some of those appeals took to argue. The semi-autobiographical work, Easing the Passing, we've got to mention this evening, is an example of Devlin's pursuit of controversy. He went looking for a fight and he found it, because he'd been harbouring, obviously, the revenge on Viscount Dillon for many years. Some of his personal notes which he made can only be consistent with him planning that for many, many years before he actually delivered the work in 1985. And when it was published in London, it divided legal London right down the middle. There were those who thought he should never have written the book, and those who thought it was the best read they'd ever had in their lives. But there were people, very senior people in the profession, like Lord Salmon and others, who came out publicly criticising Devlin. One of the reasons they came out to criticise him is that Dylan had long since died 5 years before, and some thought it was rather unseemly. Devlin said in an interview with Joshua Rosenberg, however, in defence of his position, that it was perfectly sensible for him to have done so, and he thought that Reggie, as he called him endlessly in the book, gave as good as he got, and that one day, he said, someone might write about me, and I hope they write the truth when they write about me, which was a bit of an encouragement. Now, as COVID rages on, I don't consider a Pulitzer is necessarily on the cards, nor do I expect a call from Netflix in the near future. But it was a great joy to write it. It did keep me off the streets. And there are two groups of people that I have to thank fundamentally, although the rest are thanked copiously in the book. The first, of course, is my family, who put up with me during the writing of the work. And secondly, the staff in the law library here is magnificent. They were professional beyond any expectation on my part. Their generosity was boundless, and any inquiry, mind you, they often don't have much to do up there because of the internet, I suppose, but nonetheless, I applaud them, and they were a rock for me to rely upon. Thank you, ladies and gentlemen, and thank you very much, Mr. President, Mr. Justice Leaning and Chief Justice, for hosting.